The broadcast is now starting. All attendees are in listen-only mode.
Hello, everyone. Welcome to the PanV VADER Online for Advanced Users webinar. Myself, Michael Maschke from Sensei Enterprises. I'm the Chief Executive Officer, and Dan Gray, a partner at Cooper Ginsberg Gray, are going to spend the next hour to hour and a half going through VADER Online and some of the advanced and new features, including the new Pendente Lite support guidelines here. So why don't we start off with Kathy to do a little introduction and to thank the sponsor, and we'll go from there.
Okay, thank you, Mike. I want to thank, I'm the president of the Paralegal Association of Northern Virginia, Kathy Ingram. I want to take this moment to thank Karen Axel for setting this up. This is the first time we've done a virtual VADER, and it's been amazing, the response. So we might be doing it in the future as well, because we were able to get people from like Virginia Beach area and Alexandria. So it's been very good, and she's really done a great job in handling it. Also, thank you to Patriot Process Service, Charlie Profit, for not providing dinner because we're all virtual, but he usually does, his company provide dinner, and it's always very good. And finally, you did the introductions, Mike Maschke, of yourself, and Dan Cooper, I'm Dan Gray of Cooper Ginsberg Gray. I really appreciate, Dan, you being here again. And Michael, I hope we can repeat this every year with you joining Dan. At that, let's get going.
Well, Kathy, thank you. Everybody, good evening. It's a pleasure to be here with all of you. It's sort of an unusual format for me. I'm sitting here at my computer by myself talking to nobody with no audience feedback. And when I normally do this for PanV, it's nice to see everybody, lots of paralegals, lots of attorneys. So hopefully I won't be off my game in the presentation tonight. We do want this to be an interactive program, and I promise you, I know you're looking at a static screen right now. This is actually the screen that's on my computer, and I am going to be jumping around to a couple different websites, a couple different documents, so I will do my best to keep it interesting for you. We are trying to get you some CLE credit for this, so what we're going to do is we're going to spend some time going over a review of how we got to the new Pendente Lite spousal support guidelines, which will be effective on July 1. The other thing we're going to do is review how we got to the what they call the mixed custody child support guidelines, which are new as of 2018. So I'm going to take you through how these types of things are developed, the legislative process for it. I'm going to give you some legislative history, and I promise you not only to give you the CLE credit, but to also give you a sense of how the process works when it comes to the support figures that we're plugging into VADER. Because if you understand that, I think part of what I'm going to try to do for you is to put you in a position to explain this when you're in front of a judge or when you're preparing the information for an attorney. We're also going to show you after that part how VADER works, how VADER Online actually works, and we'll try to use a hypothetical to do that. Throughout the presentation, you will have the ability to ask questions. And Mike, why don't you tell the folks how we're going to handle that?
Well, if you have any questions as we go along, you can either there's a little option to raise your hand in the panel, or you can type something into the question box, and or you can go ahead and just type in the chat and send to everybody. And as Dan goes through sort of the slides and VADER Online website, I will monitor the chat and the questions and make sure that the questions get answered in a timely fashion. And I've already gotten a question, at least from one or two attendees, that are having problems with the audio. And I just sent out, I answered one of the questions. There is a phone number that you can dial into along with the PIN that was included when you registered. so that you can get the audio that way if you're having issues with hearing the audio over your computer system.
All right, great. And I have instructed Mike to interrupt me at any point. I can pick up at any stage. I should be okay. As you can see from this agenda sheet, there are 3 email addresses, and I want to draw your attention to that because we do get questions from time to time about how to use VADER. Now, if you're having technical trouble with the program, you would email support@VADER Online. And I'm going to let Mike correct me if I say anything incorrectly, but that will go to Sensei, and they will take a first cut at determining what the issue is. Now, if it's a legal issue, and we do get a lot of questions about, hey, I have this particular scenario, what sheet should I use? Or, you know, one of the variables that I need to input, I'm not entirely sure which number I should be using. Those sorts of questions, you feel free to contact me at any time, and I'm happy to talk you through it. I don't get a tremendous amount of those questions, but I'm always happy. You know, I can usually get back to you, or try to anyway, same day, to answer any application questions that you have. Like if you have a particular set of facts and you're wondering what to do, don't hesitate to contact me because I'm always happy to talk through those things, and I actually end up learning probably as much as you do when we do that. Okay, so first issue we're going to cover tonight are the new Pendente Lite spousal support guidelines. And as most of you know, the Tax Cuts and Job Act revoked the alimony deduction, which I think caught most of us practitioners completely off guard. And effective as of December 31st, 2018, unless the parties had executed a written agreement or obtained a final alimony order before that date, any alimony was going to no longer be taxable to the recipient or deductible by the payor. And I think a lot of us were caught just completely slack-jawed as that was making its way through Congress. Clearly, it's an effort to raise tax revenue, but it has a significant impact on what the lawyers can do in terms of shifting the tax burden between the parties when negotiating spousal support. Now, alimony does remain deductible if it had been awarded in a final alimony order prior to December 31st, 2018, or if the parties' agreement was entered prior to December 31st, 2018. And so if you go in on a modification, you should be able to grandfather in that deductibility, but it has to expressly state that it's going to remain taxable to the recipient and deductible by the payor. Now, that's all impacted what had previously been done back in 2007. In 2007, Virginia adopted statewide Pendente Lite guidelines, but those guidelines only applied statewide in juvenile courts. And I've given you the code citation there, 16.1-278.17:1. Every juvenile court in Virginia, when faced with a Pendente Lite issue, had to apply the presumptive Pendente Lite spousal support guidelines. Now, circuit courts were a different story. Circuit courts were not authorized, or were not required, rather, to have a presumptive Pendente Lite spousal support guideline. So some circuits, like the Fairfax County Circuit Court, like the Ninth Circuit, and Richmond, Harrisonburg, they developed their own circuit court guidelines, which in some cases were different from the juvenile court guidelines. And those circuits actually ended up doing some pretty interesting things. I want to show you one example that you can see on VADER. The Ninth Circuit, for example. Now, what I'm doing is I'm showing you VADER online. So this is most of you hopefully know that this is the home page when you log into VADER. And I want to show you what the Ninth Circuit does when it comes to support. So you go over to your left, sort of your dashboard, and you see support. and you see C9 or Ninth Circuit Support Guideline. If you were to click on that, we're gonna use child and spousal support as an example, and I'm going to show you this because it is a guideline that can be useful if you're trying to argue for a deviation in any other circuit, and I promise I'll tie all this together for you. But basically what the Ninth Circuit did, and I'm going to do a quick consult and I'll come back and I'll explain. For those of you who don't necessarily know what that is, I'll explain that later.
Hey, Dan.
Yes,
We
Mike.
got a quick question here
Sure.
from Kimberly Phillips. She asks,
Yes.
after December 13th, 2018, when you go on an MTA, how does the court have the authority to grandfather the modification under the old law?
When you go in on a modification on a what?
MTA.
Motion to, I guess that's maybe the writer could clarify what an MTA is, but if it's a modification of an order that had been previously entered, I believe that can still be classified as deductible by the payor and taxable to the recipient, I believe. But I'm going to double check that in the course of this conversation.
Okay.
The parties can agree to that as long as the agreement was executed prior to December of 2018. If it's an agreement, and court orders, same thing. You should be able to grandfather it if it was originally deductible and taxable. So we're now looking at the Ninth Circuit support guideline, and what the Ninth Circuit did was they took into account debt service. So they would run a spousal support guideline. They had their own guideline. But then what they did was they adjusted the presumptive number to take into account certain family expenses. And I'll just do a really quick example for you. Let's say that the monthly gross income of the wife is $4,000 and the monthly gross income of the husband is $10,000. What you can see here is that the Ninth Circuit allows you to take into account certain family expenses. So if the parties are separated and the wife is in the marital residence, you see right here, monthly mortgage or rent. Let's say she's paying $2,100 a month for the mortgage. The husband has now moved out. He's paying $750 a month for his rent. I'm just going to use those two particular examples. What this Ninth Circuit guideline does is it does give you the basic guideline spousal support amount. You can see that right here. But then what it does is it adjusts that guideline to take into account what they call family debt or debt service. So you've got these housing expenses here. And if you add the wife's housing expense to the husband's housing expense, you've got a total family housing expense of $2,850 per month. And what that guideline does is divides that between the wife and the husband based on their incomes adjusted for spousal support and child support. So long story short, what it does is rather than just having the husband pay the $1,000 spousal support guideline amount, it also forces him to pay an additional $1,082 to the wife because it's dividing debt as well. So that's an example of some of the innovative things that the different circuits were doing after the 2007 guidelines were passed. Now let me just get back to the full screen here. Okay. Now, I believe that guideline down in the Ninth Circuit was developed primarily at the request of the judiciary, and particularly in some of the smaller jurisdictions in Virginia, when people were elevated to the bench, there were a lot of generalists that had done, at least when I started practicing back in 1996, there were a lot of generalists that did a number of different things before they got on the bench, and a lot of them did domestic relations cases. And in some of the smaller circuits, you're still going to find that. But many of the judges in the larger circuits now, and we're talking about Fairfax, Richmond, Virginia Beach, they were specialists before they got on the bench, because a large jurisdiction is going to allow the lawyers to specialize in certain aspects of the law. So, for example, I'm in Fairfax. I can afford to specialize in domestic relations law because there's enough business to support that. You know, if I was in a smaller jurisdiction, I might have to do wills and trusts. I might have to do criminal law. So in a jurisdiction like Fairfax, you have a lot of specialists, and there aren't a lot of judges that have represented family law clients before. So consequently, the bench typically, and I don't want to cast a wide net here, but I would say typically the bench is not as active in developing these sorts of guidelines as they were in the past, because they don't necessarily have the background for that. Consequently, it's more important than ever when you're running the guidelines, when you're using VADER, that you understand the law, because you have to explain it to the court. You cannot just run the guidelines and think that it's automatically going to be understood. There's a lot of different information that goes into these child support guidelines and spousal support guidelines. And at any given point, you're going to have to be able to explain to the bench why you're using a particular number. Okay. So 2007, we adopt a statewide juvenile court guideline. Now, did those guidelines assume that spousal support would be deductible to the payor and taxable to the recipient? The answer to that question depends on who you ask. And I had talked to many of the people like Dick Bird, Judge Dennis Smith, who were involved in the 2007 guidelines, and you would get different answers depending on who you talk to. On the one hand, people would say, well, you know, we didn't worry about deductibility, because if you're talking about a pendente lite guideline, during the pendente lite period, most people are going to find it more advantageous to file a joint tax return. And if you're going to file a joint tax return, you're not going to report any alimony. So we didn't think about it. You talk to other people that were involved in the effort, and they're very certain that, oh no, we considered deductibility. We considered the tax impact to the recipient when these guidelines were developed. So I think the short answer is nobody knows for sure when those 07 guidelines were developed whether deductibility was really taken into account. Now, the old statewide guidelines, if you didn't have children, the guidelines dictated that 30% of the payor's gross income minus 50% of the payee's gross income would give you the temporary alimony amount. If there were children, 28% of the payor's income minus 58% of the payee's gross income, that was the guideline. Now, it's very important to bear in mind that these guidelines are only presumptive up to a combined gross income of $10,000 per month. That's a key thing that you have to keep in mind with these guidelines. Above that amount, if they're earning more than $120,000 a year combined gross income, there is no presumption in terms of the application of these spousal support guidelines. So for those of you who are in a case where the other side, let's say you've got a high earner, $400,000, $500,000 a year, opposing counsel wants to run the guidelines all the way up and just ignore that $10,000 a month presumption limitation, you should be arguing that, look, these guidelines are not presumptive above $10,000 per month. You have to look at need, you have to look at ability to pay. Of course, if you like the number, you're certainly going to be arguing that, look, if you give the court a guideline, the court's going to apply a guideline. And many times that ends up being true. And part of the reason these guidelines were developed is for predictability and also to help people settle. Because if the court consistently applied it, no matter the income level, then you generally knew what you were facing if you went to court. And again, the bench was involved in the development of these guidelines and figured that if we could give people a guideline, it would help settle the case, it would help control the docket. So in any event, that's how we got to where we are now. But then the 2018 Jobs Act comes in and just takes away that deduction entirely. So now what do we do? Well, we have to start thinking about adjusting those 2007 guidelines because of the changes in deductibility. And the other thing that we started hearing a lot about was how courts were adjusting numbers to account for the lack of deductibility and the fact that alimony was no longer taxable to the recipient. So those were the major concerns. So how were the new guidelines developed? And this is, I think this is worth talking about because again, this kind of shows you what the legislative history was, and I'm hoping to demystify some of it because I think, you know, sometimes you think that there's a bunch of economists and judges and lawyers sitting together in a room and doing multiple studies and coming up with numbers that make sense, and that's not necessarily how it works. So because of the two issues about deductibility and lack of uniformity, the Virginia Family Law Coalition elected to study the issue. And for those of you who are not familiar with the organization, the Family Law Coalition is simply a group of lawyers, experienced lawyers, and it's a committee of the Virginia Bar Association. You know, the Virginia Bar Association is a voluntary bar. You don't have to belong to it. You pay dues if you want to belong to it. The Virginia State Bar is mandatory, and consequently, the Virginia State Bar is generally prohibited for lobbying for things like a change to the alimony guidelines, but the VBA has no such restriction because it's a voluntary bar. Many years ago, Betty Thompson, who practiced in Arlington, formed the Virginia Family Law Coalition, and the coalition's job is to monitor legislation in the General Assembly as it comes up, and if it's a matter of significant import, the coalition meets, reviews the bills that are up for voting, and decides to either support, oppose, or take no position on a particular domestic relations bill in a given legislative year. But the coalition also proposes legislation when it's appropriate. And so what the coalition did was formed an ad hoc study committee to look at the impact of the new tax laws on the spousal support guidelines. The committee was headed by Larry Deal down in Richmond, who does really amazing work. And what Larry did was got together a couple of expert CPAs. He got Bob Raymond, and I'm completely blanking on the other member of the. It's in your materials, incidentally. If you have the PDF materials, you have a copy of the report that Larry put together on the spousal support guidelines, and I'll just tab down to that really quick so I can give credit where credit is due. Let's see. Larry indicates that it was Bob Raymond, and I should also credit Doug Sanderson for Fairfax for bringing this issue to the attention of the coalition. He really started the process for us. Bill Colsar was the other CPA that helped Larry, and what the committee did was looked at the tax impact. And so the CPAs ran a series of numbers, and those numbers are also in your materials. They showed what the tax impact on the lack of deductibility and the lack of taxation, what that impact was on the existing guidelines. And in the process, they developed a report for the coalition. And the coalition used that report to propose legislation. Let me get back to where I was here. A little bit clunky. Okay. So the committee studied the net effect of the new tax laws on the payor and the payee. And the committee initially came back, and what it attempted to do was spread the economic pain equally between the payor and the payee. In other words, let's try to, we're going to reduce the number that the payee receives to account for the fact that the payee is not going to be taxed on it. And we're going to give a smaller break to the payor than the payor was getting when support was deductible. And so it kind of spread the pain equally between both the payor and the recipient. And the coalition discussed that, and a policy decision was made that really the approach ought to be that the least amount of pain is inflicted on the recipient. Because if you're getting spousal support, we want to try to keep you in the same position that you would have been in terms of the net effect prior to the passage of the Tax Cuts and Jobs Act. So that was the policy decision that was made. And that's also in your materials. And so the committee proposed legislation, which eventually became House Bill 1500. And this is where I think it's worth spending a little bit of time talking about the progression of bills like this, because I think it's important. Because if you are in a situation where you are trying to explain, and I think this also becomes relevant in the child support calculations, you're trying to explain to a judge perhaps what the policy is behind a change like this, right? And so what you can do, you know, there is no such thing. When I was back in law school and we used to have to like shepherdize things and look for written legislative history, that has all changed. And so the written legislative record is fairly thin. But if you're ever in a situation where you're trying to figure out the province of a particular amendment to a statute, like we're doing this year effective July 1, you can always go and check the Virginia Legislative Information System. And you just passed in 2020. And so you would click on Legislative Information System 2020 session. And if you want to search a particular bill, you would do that. We happen to know in this case that the Pendente Lite spousal support guidelines were changed through House Bill 1500. So we could click on bills and resolutions here, search House Bill 1500, and that would give us the entire legislative history. You can also look based on subject matter in a particular legislative year. So if you had a domestic relations issue and you're looking at a statute that was amended in, say, 2015, you would just go to the 2015 session here and you would look at the subject index and look under domestic relations and then just search for bills that are relevant to that particular code section. And I'll show you what I mean. But since we have House Bill 1500 in front of us, you just search HB 1500, and there it is. Delegate Chris Collins out in Winchester, he's the one that introduced this bill for us. He patroned it. And as you can see, it sailed through fairly easily. It goes through, since it's originated in the House, it goes through House courts, and the subcommittee voted in favor of it 7-0. It passed the full Courts of Justice Committee 22-0. Passed the House by 97-0. No opposition whatsoever. It then crossed over onto the Senate side, reported out of the Judiciary Committee 15-0, and then it passed the Senate 40-0. So through the entire process of debating this Pendente Lite guideline, there wasn't one member of the General Assembly who voted in opposition. And that's not unusual for support bills. Because it was, if you look up the mixed custody guideline legislative history, which we'll do in a minute, you'll find the same thing, that generally support-related bills, you know, depending on who's testifying in favor of it in front of the House subcommittee or the Senate committee, they're generally going to be deferential because they know that the work was done prior to the bill being advanced. again, I'm making a blanket statement there, but if you look in your materials, and I'll click back to that, if you look in the materials that I gave you, Larry's report to the Virginia Family Law Coalition, let me just tab down there again. Yeah, Larry gives you all of the mathematical presumptions, all of the background reasoning behind why we needed to change the spousal support guidelines. So in any event, that's just a little tip if you're ever in a position where you're trying to figure out why a particular statute was amended, what was the legislative intent behind it, when they used this word, what were they talking about? You can click on the legislative history and get at that information. Now, what am I talking about? Well, if you go back to the 2020 session, you see here that you've got Senate video. Well, every single bill that where the Senate or the House takes testimony on a particular bill, that's all video recorded. So I happen to know that I was there testifying in front of the Judiciary Committee on February 24th, I think. Let me just see. Judiciary, February 24th. I was down there, and I can click on that video. And if you, I had to wait there all day. And I'm sorry if Mike, you'll tell me if this is too loud. I don't know if anybody can hear it.
Yeah.
There I am testifying about HB 1500. So if you are really interested in what the senators or what the delegates were asking on a particular bill, or there's a legislative interpretation issue, go back and watch the video. You know, and the reason I know that it was that particular day is, again, if you search HB 1500, and I promise you we'll get to VADER in a second, I just want to show you this. If you search HB 1500, you'll see that it was reported from the judiciary on February 24th of 2020. So you know that the Judiciary Committee met that day, took up the bill, and were debating it. So again, that's how you would find the legislative history behind something like this. Now, what does all this mean? Why am I spending so much time on it? Well, I'll get to the bottom line on what was changed. So we'll go back up to the new Pendente Lite spousal support guidelines that were adopted because of House Bill 1500. Well, the big news, and this is important, is that these guidelines now apply to every circuit court in Virginia. Okay, I said before that there were only about 4 circuits that had their own guidelines. Well, back in 07, we tried to get it applied to every circuit court, but the General Assembly didn't like it, and so they came at the coalition and said, would you accept statewide application to the juvenile court? And in order to get that guideline passed, we said yes. Well, this time around, we didn't know if we would get it adopted by every circuit court, so we gave it a shot, and as you can see, it was unopposed. So these guidelines now apply to every single circuit court in Virginia. Loudoun County, Prince William County, for those of you in Northern Virginia, all circuits. Now the question is, what happens to that 9th Circuit guideline that we looked at? You know, they had that really innovative way of dealing with debt service. Well, I think the answer is, for practitioners, is that, again, if you've got a case where the combined gross income is over $10,000 per year, you should be fine. Because again, the statewide guideline is no longer presumptive under those circumstances, and I think you could very easily argue, if you're in the 9th Circuit, that you could apply the old guideline, okay? Now you're gonna have to adjust the percentages, but I think you can still use the debt allocation as you had before if you're above $10,000 combined gross income. You could also probably argue for a deviation, because the bill itself and the new statute states that you can still deviate from the guideline for good cause shown. So if you happen to be in the Ninth Circuit, or any circuit really, if somebody is paying a significantly high mortgage or is paying a lot of credit card debt, those are the sorts of things that you should be arguing would justify a deviation from the presumptive guideline for good cause shown. So what happens to the Ninth Circuit guideline? I think you can still argue for its use if you want to. Now, the $10,000 monthly cap, that still applies. The percentages have slightly changed. And I know that this is a huge windup for kind of a lousy pitch because the percentage reductions weren't all that significant. But now if you don't have children, it's 27% of the payor's gross income minus 50% of the payees. If you do have children, 26% of the payor's gross income minus 58% of the payee's gross income. And that's going to apply to all cases filed after July 1 of 2020, and that's right in the statute. Now, will you be able to use these new guidelines effective July 1 in VADER? And the answer is yes, you will. Right now, we are in beta testing on this. So what I'm going to do is show you, just bear with me because I have different passwords for different VADERs. This is not publicly available, so I'm giving you a sneaky peek at what will be coming out effective July 1. Okay, so support, I'm going to use, I'll use the combined support. I'll do spousal support. Put consult. Okay. Well, let's see. Let's do combined support instead. Okay. Now, what should happen, you see two different versions here. You see version 1 current, and you see version 2. All right. We're giving you both of those options because if the case was filed prior to July 1 of 2020, you're going to have to use the old guideline. If it was filed after July 1 of 2020, you're going to use the new guideline. Mike, remind me again, it's going to default to either version 1 or version 2, depending on when you create the case file or depending on when you log in. I can't remember.
It's depending on when you log in. So
okay,
after,
so
after July 1st, when you log in, you will be presented with like what you see here on the screen, I believe, version 1 and version 2, and depending on which version of the support guidelines you need, you would click on the appropriate tab.
Okay, so we're going to assume that we're doing this after July 1 of 2020. We're going to click on version 2. Okay, so and you can see it's changed right here. It says per Virginia Code 2103 and 16.1-278.17. So now that it applies to the circuit court, we've got to reference the PL relief section 2103 and also the previous JNDR guideline. So again, I'm just going to plug in some fake numbers here. 5,000 a month for the wife. Let's do 25,000 for husband. Now we were having some issues with, I'm going to use 0 kids for that. Let's see if it gives me the right numbers. And we're still having issues. Let's see if I put in 2. No, let's see what worksheet I wanted to use to show you that. See if spousal support does it. Yeah, so the spousal support worksheet has got the appropriate percentages in there. So by July 1, we'll have this up and running, but you've got 2 kids, so we're using the 2658. Let me just see if I change it to 0, whether it's going to give me the correct percentages. Yep, 27 and 50. Okay, so again, it's not going to make a huge difference in the bottom line number unless you run it all the way up. And if you're the support payor and the other side is trying to run it all the way up, you're going to argue that, hey, it only goes presumptively up to $10,000 a month. And I think we tend to forget that. And so a lot of times, even in settlement, lawyers they use that guideline no matter what the gross incomes of the parties are, and it can sometimes result in unfair results. Okay. So that is my presentation on the PL guidelines. We're going to move on to the mixed custody guidelines, and I do realize I'm taking a lot of time here, so I'll try to, so I can show you all the different aspects of VADER. I'll try to make this quick. Same sort of thing with mixed custody guidelines. These were changed in 2018, and the Family Law Coalition was asked by certain circuits to study situations where you had unusual custody arrangements. So for example, let's say that you had 3 children and 2 of the children were shared the same number of days. Let's say they were shared equally between the parties. But you had a 3rd kid who maybe spent a 1/3 of his time with mom and 2/3 of her time with dad. So you've got 2 kids being shared equally and 1 kid being shared 1/3, 2/3. What do you do? Or if you have a situation where, again, you've got 3 kids, 1 kid lives primarily with mom, and so you would use the sole custody guideline, but then you've got 2 other kids who are being shared between the parties. What do you do in that situation? So the Family Law Coalition was asked by, I believe it was the Virginia Beach Circuit Court, to look at those sorts of situations and to come up with solutions for this. Steve Rayner was the chair of that particular subcommittee. He's down in Charlottesville. Larry Deal, again, was involved in that. And Mitch Brody, who is down in the Virginia Beach area, who is just a fabulous attorney and a mathematical genius and an Excel genius, really worked very hard on that committee to come up with the mixed custody guidelines. And a key to understanding the mixed custody guidelines is the Mixed Custody Guidelines Committee rejection of the concept, and it's down here, rejection of the concept of the first child being the more expensive child. And what do I mean by that? Well, we all know that when you run the child support guidelines, if you run it for 1 child and then you run it for 2 children, it does not double. It just increases incrementally for every additional child that is the subject of the child support order. So for example, if 1 child is $1,000 a month in child support, if you add another kid, it doesn't become $2,000 a month. It becomes something like $1,475 a month. And why is that? Well, when the initial child support guidelines were developed, the idea was, look, that first kid is the most expensive kid. Let's say that you're a father, you've separated from your spouse, you got to go find an apartment. Well, if you don't have any kids, you're going to go find a 1-bedroom somewhere, right? But if you have a child that you're sharing custody of, now you got to run a 2-bedroom, right? There's an additional cost involved in that. You got to buy food for 2 people. You may have to, I don't know, you might get cable, whereas you wouldn't have had cable before. There's a significant sunk cost involved in having a child with you for some period of time. Now, you're in a 2-bedroom apartment. Let's say you add a 2nd child. Well, you may not need to get a 3-bedroom apartment. Maybe you can put 2 kids in that 1 bedroom. So your costs don't double, they merely increase incrementally, because now you got to buy a little more food. Your electric bill might be a little bit higher, your water bill might be a little bit higher, you might have to get, another car seat, but you're not doubling your costs with every child that you have. That was the fundamental premise of the child support guidelines. But when the committee looked at these mixed custody arrangements, the problem was it made the calculations too complicated. That's really what it came down to. You had to balance ease of use against this concept of the first child being the most expensive child. So I've given you sort of the general approach and summary form for each of these different scenarios: mixed shared, sole shared, split shared. And I will circle back with you and I will do some examples based on the hypothetical. The other thing that's really important to remember about the mixed custody guidelines is this 1/4 shared custody multiplier. Whenever you have shared custody, in a regular shared custody calculation, and for those of you who already know this, forgive me, but I feel like this gets missed. And again, this is one of those things that needs to be explained to the court in many circumstances, so I want to make sure I cover it. When you have a shared custody guideline, let's say you have 2 kids. If it was a sole custody situation for 2 kids, let's say it's $1,000. The shared custody multiplier multiplies that sole custody amount by 1.4 when it's deciding what the shared custody guideline is. Why is that? Because it's more expensive to share custody of children than it is for one parent to have sole custody. Go back to my example of the father in the apartment. If the mother has primary custody, and we're using the sole custody guideline, maybe the father doesn't need to get a 2-bedroom apartment. Maybe the father can sleep on the couch and the kids can be in the bedroom. It's not as expensive if there is not shared custody. Now, if he's got the kids half the time, he's going to have to get a 2-bedroom apartment. He's going to have to buy more food. He might have to get a bigger car to go on trips. So because of that recognition, that's why you multiply the sole custody guideline by 1.4 when you're in a shared custody situation, because again, it's more expensive to raise a child in a shared custody arrangement than it is in a sole custody arrangement. At least that's the premise. That's the idea. Okay. So those mixed custody guidelines, and I've given you Steve Rayner's report in your materials. I won't go over it now because we're rapidly running out of time. But that was Senate Bill 951, and that was passed during the 2018 session of the General Assembly. And again, just like we were talking about HB 1500, you can go and look for that Senate bill if you were interested in seeing how it kind of made its way through. If you wanted to look at the testimony on it, you could do that if you wanted to search the legislative history. Okay, so that is my CLE portion of the program. I hope that that was somewhat useful to you. Let's move on to the hypotheticals. And the first hypothetical that we're going to use is the sole shared arrangement. So what I'm going to do now is I'm going to take you through VADER Online. And what I'm going to do is start from the beginning. I'm going to log out. I'm going to log back in. And this is not the development site. This is the regular VADER site. Let's see if I got my password correct. All right, we're in. Now, when you log into VADER, you've got 3 different options to kind of get into these different worksheets over here. Okay, if you were going to start, well, I mean, if you want to do a quick calculation, okay, and you really didn't want to spend a lot of time filling out a lot of information, you just want to see. You want to run some quick numbers, and so you click on support and you want to do child support. You're going to get this notice, please start a case before accessing this page. Well, you can bypass all that and just do quick consult. And I've hit that. And now it's given me a quick consult file, and this now gives me access to all of this information here on the left-hand side, so I can get into any worksheet that I want. But for this particular example, I want to download something that I've already done. So I'm going to download a case. Oh, no, I'm sorry. That's different. Mike is rolling his eyes at me, I'm sure. Okay, So what I want to do rather than download is upload. I'm going to upload a case that I had kind of put together for this presentation. Now this can get complicated for those of you who aren't really used to doing it. You hit upload case. Well, first you got to choose your file. All right. When I download something on my computer, I'm doing this on my PC, it automatically goes to the downloads file. You can change your computer settings so that it goes someplace differently, like your desktop. Mine just goes to downloads, okay? And I click on the case that I want, that I've already saved, and and it tells me what it is right here. Now I'm gonna upload it. It just takes a minute. You can see this processing. Okay, now it tells me that my Sussex case has been uploaded. And any information that I had previously saved, if I hit download case when I was working on Sussex, will be saved in there. So for example, you can see that I have already populated this file with personal information. I'll just give you an example there. See, I've got all the information about Megan Sussex, Harry Sussex. I've put all of this in, and it should all be available to you. So every time you download the case, you should save your information. Okay, so let's go to our hypothetical. Megan is married to Harry. They have been married since 2015. They have 3 kids. Megan is employed as a CEO, and I think to be, rather than being rude, I'll put my I'll put my hypothetical in front of you. Harry is a self-employed, owns his own real estate company, receives K1 income of $425 a year. Megan provides the health insurance for the family at the cost of $100 for the employee, $100 per additional person. Unfortunately, Megan discovered Harry cheating. The parties agreed that they would separate. They share custody of 2, Brindle and Smythe, but they've agreed that Megan, because Mayberry is only 1 year old, Mayberry is going to stay primarily with Megan until she's old enough to be in preschool. Megan's daycare expenses are $20,000 per year. She's got a live-in au pair. And Brindle and Smythe are in preschool, which Harry uses as daycare, and that preschool costs $2,000 per month for both children. What are the pendente lite support guidelines in this scenario? All right, the key principle when you're dealing with something like the mixed custody guidelines, and let me get to those. I'm gonna hit support, mixed custody, and we're doing sole shared. I think the best way to proceed when you are doing particularly the mixed custody guidelines is to go line by line to make sure that you're not missing anything from top to bottom. So the first thing you're going to do is make sure that you've got the appropriate monthly gross incomes in there. All right. Now, these mixed custody guidelines, you know, at a certain point, it becomes too unwieldy to include both spousal support and child support. And so you're going to have to calculate guideline spousal support on another sheet. So what I did before I populated this was I ran in this other place under support, I ran spousal support guidelines so that I could go in and I learned that the guideline amount of support right now for Megan would be $4,117 a month. Okay, so that gets deducted from Harry's gross income. It gets added to Megan's gross income. Are there any other biological children or adopted children residing with either party? As we know, if there are, but they're not the subject of this particular case, you get a break on gross incomes for that. So if Harry had a child from another relationship, VADER would automatically give you a deduction under the Virginia Child Support Guidelines for the fact that he had that other child. Okay, now, if you don't want VADER to do that, and Harry is subject to another child support order for another child, well, you can put that number in right here. Other child support obligations actually paid out. if I didn't happen to come up with it, but if as a self-employed individual, Harry had any self-employment tax, I would put that down here. And VADER calculates that each party's gross income share after consideration of spousal support is 68.92 and 31.08. All right. Based on that, I've already inserted for 3 children, the guideline amount is $3,803. Now, because we're in a mixed custody situation, what you do is divide that sole calculation number by 3 children, and you get 1,267. Again, that right there is the rejection of the first child being the most expensive child concept. Okay? Now let's figure out for the child that Megan has for Mayberry, how many kids does she have sole custody of? Well, we know she's got 1. She's got Mayberry. What is the child support that she is owed, or what is the child support that we're going to assign for Mayberry? Well, we already decided right up here that each kid is worth 1,267. So that's the sole custody number that we're going to use for Mayberry. And then that gets divided between the parties based on their monthly income shares. And so for Mayberry, Megan is owed from Harry $873 a month. All right, so that's step 1. Now we got to figure out these other 2 kids that they're sharing, what's the amount going to be for them? Well, we know that if 1 kid is worth 1,267, then 2 kids is going to be worth 2,535. We just multiply that number by 2. But because this is a shared situation, we got to multiply this number by 1.4. All right. So you don't do anything there. VADER will do that for you, but I'm giving you the background there to understand what those numbers are. Now, I have decided that they're going to share these other 2 kids approximately an equal number of days, but if you wanted to share them somewhat unequally, let's say Harry had them for 110, you would just put that number in there and this will automatically adjust. But for our purposes, I'm going to say that they share approximately equally. Okay. VADER calculates each parent's custody share. You multiply the basic support amount. And again, VADER will do this for you. And the end result is Megan is owed $676 for the shared child. Now you'll notice we haven't done anything with regard to health insurance. We haven't done anything with regard to daycare expenses. That's the 3rd step in the mixed custody calculations. Now, I have this incorrectly because I said that Megan was paying for health insurance. She's paying $300 a month for the children, all 3 of them. She's got $20,000 a year or $1,666 a month in daycare expenses. And I said that Harry, let's see, he has the children in daycare and that costs $3,000 per month. Okay, now the guideline looks at those expenses and assigns them in proportion to income, and these healthcare costs, work-related daycare costs, okay? And so the amount parent owes other parent for healthcare costs, work-related daycare costs based on income share. All right, we're going to divide the total expense based on their income. And since Megan owes Harry $932, Harry owes Megan $1,354, the difference is $422 a month. Okay, so we know based on this worksheet that for the first kid, let's see, the first kid, Harry owes Megan $873. For the other 2 kids who are shared, Harry owes Megan $676. Now Harry owes Megan $422 for the daycare and the health insurance expenses. And you add all that up, $873, $676, $422, it comes out to $1,972.62. And that is the amount of support that is owed to Megan. Now you can come down here and you can make adjustments if you want to. If Harry is making some kind of direct payment, you want to give him credit, you can do that there. But you can see that in that sort of situation, it's really imperative that you go through every subpart of the different worksheet to make sure that you're getting all the relevant information put into the worksheet. Now, that's situation number one. Let's go to the second hypothetical. Okay, this time we're going to do multiple shared. Now we've got a situation where we're going to share custody of all the children, but we're going to do it a different number of days. Okay, so 2 of the kids are going to be shared approximately equally. But because Mayberry is relatively younger, Megan's going to have her for 200 days, and Harry has her for 165 days. So different percentages. All right, what do we do in that situation? Well, we go back to VADER, and this time we're going to do multiple shared. And we give VADER a minute to get to the proper page. Again, multiple shared custodies, all children shared, but differing numbers of days. Okay, same analysis. Number of kids involved, we've got 3. Parents' monthly gross incomes, we've got that. We've made our adjustment for spousal support to each. We're not doing any credit for self-employment tax, although we probably should. Nobody else has kids outside of this particular relationship, so we're not making any adjustments there. And we determined that if we've got 3 kids and we use the sole custody guideline, that's step 1, it's $3,803 for all 3 children. That is the basic child support amount that's indicated when the parents have combined gross incomes of $45,000. You're earning $45,000 a year combined gross income, you got 3 kids. The state says that's how much you're spending on the total, okay? Now, we're in a shared situation, so what do? We multiply that number by 1.4 because we're dealing with a shared situation. So 1.4 times 3,803 gives us 5,325. All right, now what do? Well, we're going to look at each individual kid. And for each kid, we're going to figure out how many days each parent has that kid. Now, we know that the 2 older ones are being shared approximately equally. Total number of days each parent has custody of child 1, 182 and 183. All right, second child, same thing, 182, 183. Now we get down to the 3rd kid, and we've got a different ratio. So Megan has her for 200 days, Harry has her for 165. All right, so what? Well, so what you do is you add up the total number of days that each parent has all the kids. So Harry has at least 1 kid for a total number, and I know that this, trust me, we debated this endlessly in the subcommittee, but we figured out this would be the most, I hesitate to use the term easiest, but it's the easiest way to do it. Total number of days of all kids involved. Harry has 3 kids for a total of 529 days. Megan has 3 kids for a total of 566. The average number of days that the parent has the custody of the children is 170. Harry's got them for 176. Megan has them for 188. And so those are the percentage averages that we use. Okay. Now, we apply those percentages to the basic child support obligation, which is multiplied by 1.4. And we discover that because of the shared arrangements here, Harry has an obligation of $1,897. Megan has an obligation of about $800. So you just subtract these two, you subtract the lower one from the higher one, and you end up with $1,097. So that's how you do multiple shared. And really all you need to do when you're using VADER is just make sure you're putting the correct number of days in for each kid. And you can fight about, what constitutes a day. Is it a 24-hour period? Is it half a day? That's for you all to battle out. But once you decide on those numbers, this is where you plug that in. Again, we haven't dealt with health insurance costs. We have not dealt with daycare expenses. You do that in part 3. And again, Megan is paying, not Harry, Megan is paying $300 a month for health insurance. Her daycare cost is $1,600 and his is $3,000 a month. So VADER tells us that Harry owes Megan $377 for that, for the daycare and the health insurance. So now we come down to part D and you just add it all up together. We've already discovered that the child support amount, the basic amount, is $1,097. Harry's share of daycare is $376.90, and the total amount payable is $1,474. Okay. Split shared, which is another mixed custody guideline. Same sort of analysis. I'll just hit on that real quick. That's where you've got a situation where you're splitting custody of 2 or more children and share custody of 1 or more other children. And again, I'm not going to go over that one as well because there are other features of VADER that I want to show you. But those are the 3 mixed custody arrangements. And again, you don't have to change this for July 1 because under mixed custody, none of these automatically calculate spousal support. All right, to find the spousal support number, you're going to have to go under support, and you'll have the 2 options under combined support and spousal support. Effective July 1, you'll be able to use the new spousal support numbers. But to adjust the incomes for spousal support, you're going to have to use this worksheet first, get the spousal support number, and then import it over into the mixed custody guidelines. Okay, so we've covered the mixed custody guidelines. We've covered the new pendente lite guidelines. Let me take you on a quick tour of some of the other things that VADER can do. Now, I uploaded this case, so all of these forms are going to be populated already with information. So we're going to use, yes, go ahead, Mike.
Yes. We got
Yes.
a question from a couple of people that are asking what happens if you have more than 6 kids?
So what happens if you have more than 6 kids? And you ask that question because if we go to support and you go to mixed custody and you go to, for example, multiple shared, go in there. You will see that we've only provided for 6 kids. We couldn't fathom a situation where you would have more than 6 kids, for example, on multiple different days. I don't know how any human being could possibly keep track of that, but I certainly suppose there are situations where that could be possible. The short answer is you would send us an email and you would say, hey, I got a situation with more than 6 kids. Can you, do you think you could insert another line or 2? Or the other thing you could do is you could do it by hand. I mean, you would just add, you wouldn't be able to show it on the sheet, but you would just add the number of days that the 7th kid, the 8th kid is being shared to these 2 numbers right here, and then you have to just divide and get a new average, but you can do it. Of course, it's a good question to see if, for example, if we put in 7 here, whether VADER is going to give us, if you have 7 kids, the basic support obligation. Yeah, I think we top out at 6 there. So I guess the short answer is you're going to have to, you're probably going to have to do it by hand. but I hadn't considered that, so we'll have to look at, see if I enter 6 here, it gives you the shared support number. But again, if I enter 7, I think we top it out there. Yeah, it doesn't go up that high. So you'd send us an email and we'd talk to the developers and try to run it up for more children is the short answer to that question. But it's a good one. That's fair. Okay, let me get back to ED forms. I wanted to show you a recent change that we made based on some user feedback that we got. For those of you who have used this program, you know that the personal property worksheet looks like this. First, I'll show you what it looks like when you print it out. So this is your standard real and personal property worksheet. If you happen to have an equitable distribution case and you want to list the marital residence, you want to list non-retirement accounts, this is what it looks like, right? And the problem that we were having with it was, well, the way you input the information is like this. Each item of property is input into this block format. And for example, marital residence, date of purchase, title, marital separate or hybrid. Now you got a second item of property. Well, you got to do the same thing over for every item of property you want. You just enter it in this format. And then when you hit print, it puts it in that other format that we saw. And what users were saying is, look, you know, I could enter 10 different things, but what if I forgot something? You know, how do I go back and insert something in the personal property worksheet? Well, now you can hit this button, turn sort mode on, and this shows you a different window. So for example, if you really want to show this First Virginia account first before, for example, the Vanguard account, you can just click on it and you can change the order. Okay? If you want to put the marital residence down at the very bottom, you can do that. So now once you've input the information, you can change the order of the listing. Okay, and that was something that you couldn't do before. You used to have to start all over again. So that's sort mode. And let me see if I can make this a little bigger for you. So that's a huge change, and that just makes it a lot easier when you're going back to the worksheet after you've worked on it for a while. You can now resort on this particular sheet all of those different entries. Now, where you can't do that, but where we will certainly think about in later versions is when you're down doing separate and marital shares of retirement accounts, for example. You know, what we've had some users say, well, look, you know, I have been putting in all this data and I forgot to input a particular contribution. You know, what do I do? Well, you have to go back up to where you forgot it, and then you have to redo it on the following dates. But we could, in theory, put that same sort measure in there as well, and we're looking at that. So in any event, I wanted to show you that. You can now sort on personal property. I want to draw your attention to options, because what we're starting to see are companies granting not necessarily stock options for compensation, but we are now starting to see companies grant restricted stock units. I'm seeing a lot of those recently. I don't necessarily know why, and maybe it's a tech thing up in Northern Virginia, but the reason the stock options sheet is important is because when you are dealing with any asset that has a vesting schedule, you have to apply the coverture fraction to determine which portion is marital and which portion is separate. So for example, very easy example, let's say that the parties separated January 15th of 2020. Okay. Let's say that prior to that time, the wife was granted 250 shares of restricted stock. And when those shares were granted, let's say that they were granted about a year before separation. So let's say on February 25th, 2019. And the grant documents indicate that these 250 shares, which were granted on February 25th, have a 36-month vesting period. Okay. Well, VADER will calculate using the coverture fraction what portion is marital and what portion is separate. Okay, and it's just a function of the amount of time that it takes to grant or vest rather these restricted stock shares. Okay, so whenever you have an asset that has a vesting schedule, make sure you use the options sheet. That'll tell you which portion is marital and which portion is separate. Really quickly, ED funds. Source of funds calculation, that is your Brandenburg calculation. And you also see down here, another question I get a lot is the refinance, the property refinance worksheet. 2 points about that. You do not need to use a refinance worksheet if there has been no cash taken out during the refi. A lot of people, especially now since the rates are incredibly low, are refinancing their mortgage, but you only need to use this sheet if people are pulling out money, okay? If they're just refinancing to get a better rate, you don't have to bother with this. They could have done 10 refinances. If they never pulled any money out, they never accessed the equity, you don't need to worry about it. You only use this sheet if people have pulled out equity from the marital residence. And the idea behind this sheet, which incidentally, Brandenburg has certainly been approved by the Court of Appeals. Other methods of calculating separate and marital shares of real estate have been approved. This refinance method has not necessarily been formally approved, but mathematically, it's just a way of readjusting Brandenburg every time the parties pull money out of the house, because when they do that, some of the money they take out in a refinance is going to be marital, and some of it is going to be separate. And every time you take out that money, you got to readjust the percentages in Brandenburg. The Brandenburg case never dealt with a refinance scenario, but this idea was developed by Dick Bird, and I believe, if you wanna kind of get at the mathematical background from it, it is discussed in the README section, so I would commend that to you. Okay, quickly moving through. Marital funds and gen funds I did touch on earlier. That's when you have a liquid asset where contributions have been made perhaps before the marriage, during the marriage, and after the marriage. You got to figure out the separate and marital shares. This will allow you to do that. Marital funds assumes that the account was begun during the marriage. Okay, so there's no premarital portion, but it then assumes that there were contributions made after the date of separation. So you use this sheet. If there was a fund that was created prior to the marriage, and maybe you've got 3 classes of contributions, you've got premarital contributions, you got marital contributions, and then you've got post-separation contributions, this sheet will allow you to figure out the separate and marital shares of that particular account. Expense, that is just your standard income and expense worksheet. Clicking on that. Okay, and again, it looks different when you're entering the information, but when you go to hit print, it looks like the old VADER worksheet that you're used to. It's a little bit bigger, it's a little bit clearer. It's now on more than one sheet, but that's what it looks like once you hit print. You have a 2-column income and expense statement for situations where, let's say you have an adult child living in the marital residence, and you want to separate out the expenses that the support recipient is paying for the adult child versus his or her own expenses, you would use the two-column worksheet, household total, supported children. So you can break it down between the two different people. Medical expense, I want to show you one thing here. Anytime you have an expense that's being shared in some proportion between the parties, you can track that using the medical expense form. Now, it defaults to medical expense, but let's say that I wanted to track, let's say that the parties were ordered to pay extracurricular activity expenses in proportion to income. I could just come in here and change this to extracurricular. I spell that right? Expenses of the minor children. Okay, I've changed that. Now when I go to print, that's the title, extracurricular expenses of minor children. So no matter what it is, if there's any expense that's being shared by the parties in proportion to income, medical expense, daycare expense, educational expense, extracurricular activity expense, whatever it is, you can change the title of this medical expense worksheet and VADER will automatically tell you what the appropriate amounts are. You know, so you just, when is it due, who paid it, what was the total expense, what should each party have paid, and who owes what to whom based on what has previously been paid. Okay. We also have a section here that allows you, let's say that Megan has run up, call it $1,000 in expenses and Harry's share is $750. Let's say he made a payment at some point of $200, but he still owes her $550. You can give him credit for that. Payments between parents directly in the period, we would say that Harry made a payment of $250, but he still owes $500, and this will account for that as well. Okay. I have run through at breathtaking speed some of the features in VADER, and I have tried to find a balance between bloviating about sort of legislative history and some of the law behind the guidelines and things like that, but I hope it's been helpful to you. Mike, before I conclude, are there any questions that I didn't get a chance to get to?
There are, Dan. One of the remaining ones is, can the categories on the income and expense sheet be altered as needed?
Can the categories on the income and expense sheet be altered as needed? Well, let me pull that up. Let me get to my dashboard. Expenses. And I'll show you. They cannot be altered. Unfortunately, you have the listing here, and if a particular, I know that in the Excel version, you could unprotect the sheet, you could go in and you could change, for example, if you wanted to get rid of or rent. Oh, no, you can't do that.
Well, one workaround is when you print it to Acrobat PDF.
Yes.
You can actually edit the PDF within Acrobat if you wanted to remove or rent text, as an example.
That's a great pro tip, Mike. So I've got it here in Acrobat, and if I wanted to say or rent.
Well, right now you have it open up in your browser. You'd want to open it up.
Yeah. So that, would I have to download it?
Yeah, go ahead and go to your download folder. There we go.
Here it is.
And
so, okay, hang on. I know what you're saying. All right. So when I hit print, it automatically went to my downloads folder. So what I'm going to do, this is print number 5. What I'm going to do is click on my downloads folder. Now I can open it up in PDF. And that's why we have Mike on the line. So now that it's in PDF, I should be able to delete it Mike, I guess I would have to open up my edit,
Yep. And edit text.
edit, and then where would it be?
Click on using PDF docs. You don't need to recognize text because it's already OCR'd. So if you click on
Right.
edit to the
Click
left
on edit.
and go down a little bit to the edit, go to the right, two icons.
Two icons.
You got design form, highlight form, edit. Sorry.
Right here.
On the
Oh,
left
well,
hand,
this is good because I am the typical user.
you are on the left hand side. You have design
Yes.
form, highlight form, and then edit. It's the third one in.
Oh, I'm sorry. I see it right there. Okay, I've hit that.
All right. And to be honest with you, Dan, I am not familiar with PDF docs, but for those users that are using Acrobat, if you go to edit, one of the options within Acrobat is to add or replace text. And when you click on that, you should be able to backspace out the word rent.
Okay.
And or change mortgage or rent to any other name you want to give it. But it is an editable file that you can do in Acrobat.
So the presenter, unfortunately, this is beyond my technical ken, but it makes intuitive sense that once it's downloaded, if you pull it up in Acrobat format, you should be able to change those entries that way, and it should look fairly seamless.
Yes.
Okay.
And so we have one more question regarding the personal property sheet. Is there a number?
Yes.
Is there a limit to the number of items?
There is. Let me go to that sheet. I think the short answer, Mike, is no, because every time if you want to add more information, I'm just getting to that sheet now.
On the personal property, yeah, I think it just keeps adding a new row.
Yeah, you would just continue adding a row anytime you had another asset.
Yeah. So the Excel sheet, I believe the previous, back in 2014, we had two versions. I think one had like 20 rows, and then you had a longer one with 30 rows, and that's where it was capped. But I believe with the website and VADER Online, there is no limit to number of rows. I just think that the more rows you add, obviously at some point it's going to go to a second page and a third page when you print it.
But you should be able to just keep clicking, add a row, and just, whatever additional property is there, you should be able to use. And you should still be able to use that sort function.
Yes.
So that no matter how many you have, you can reorder them in whatever order you want.
Correct.
Okay. Last questions, Mike, or did we cover the ones that you, as the keeper of the questions, wanted to cover?
We covered them all.
Well, I really appreciate those of you that hung in there with us. I hope you found this helpful. Let me go back to what I said at the beginning. If you ever have any questions about applying VADER, the background of the law, please feel free to email me at any time, give me a call. Again, if you've got technical questions, how do I edit the income and expense statement input variables, you would email support@VADER Online, and they're great about getting back to you the same day. If you notice things in the program that are weird, that you don't think are working correctly, email support@VADER Online. We can push out fixes to those things instantaneously. I think we've got it to a point where it should be working correctly. We're still doing the beta testing on the new spousal support guidelines, but we'll have that out before July 1. I'll thank everybody for listening. I'll thank Panvi and Kathy and Karen and Joanne and all the members for inviting me to talk to all of you again. I hope you have a good evening. Mike, anything to add?
Thank you, Dan and Mike. Bye-bye.
Thank you, everybody.
All right.
Bye.